for the Pledge of Allegiance. And by request, Mr. Lozelle, will you please use the pledge?
Sure. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Establishment forum.
Victor Pérez is absent, Renee Rodriguez.
Here.
Anthony Alvarez is absent, Jesus Reese.
Here.
Samuel Cox is absent, and Gloria Rodriguez is absent. We do not have a quorum, but we can proceed with no action.
Mr. Mayor, Mr. Rodriguez.
Oh, wait, so do I go down to public comment, or do we just start, like, as a regular meeting?
We could go down, yes.
Okay, anybody sign up for public comment?
No.
Number 5, discussion regarding sexual harassment and hostile work environment training for city council representatives and city staff.
And Mr. Mayor, my name is Bruce Taylor. I'm going to be presenting a workshop to the City Council and the department heads with regard to employment discrimination and harassment issues. It is important for both the City Council as well as department heads to be trained with regard to the state of the law, with regard to, in particular, harassment, what it is, what it isn't, and how to avoid it, and things to look out for. Now, there are numerous statutes that deal specifically with different forms and types of discrimination. These are the major ones. There are all additional statutes that I'm not going to get into, more specialized statutes, but these are the main statutory requirements for specific discrimination and retaliation. There's Title VII, which is part of the Civil Rights Act of 1964. The ADA stands for the Americans with Disabilities Act. There's the ADEA, which is the Age Discrimination and Employment Act. Importantly, all of these statutes have been adopted by Texas separately. And so there's the Texas Commission on Human Rights Act, which separately incorporates the same types of requirements under state law. And so what is generally covered when it comes to both discrimination and harassment? Well, race, color, religion, sex, national origin, age for those that are 40 and above, disability, and with all of these statutes, there's retaliation provisions as well. And so I'm going to talk a little bit about each of the separate items, and then we'll talk a little bit about retaliation and what to look out for when it comes to retaliation. I'm going to get into more specifics with regard to gender and sex harassment. Obviously, under the civil rights statutes, sex discrimination, both females or males can be discriminated against in the terms and conditions of their employment. And so there can be discrimination as far as the hiring practices. There can also be harassment issues based on gender as well, and I'll get into that more particularly. Additionally, race or color discrimination is a separate category, and obviously individuals of different racial categories can be the subject of employment discrimination and also harassment. Now, there's the view a lot of times that harassment really only deals with sexual harassment, and that's not accurate. Sexual harassment can also extend to any other protected classification. So, just as with sexual harassment being inappropriate, also harassment based upon race. And so, in those situations where you have racial slurs, inappropriate joking, other offensive and derogatory comments, that too can lead to harassment and unlawful harassment in which there can be liability. So it's important to think, when you hear the words harassment, to go beyond what we typically think of as sexual harassment. It goes well beyond that. Also, religion is a protected classification under the Civil Rights Act of 1964. And again, it can deal with slurs, jokes, inappropriate comments. We often see this in the proselytizing employee when you have someone who is trying to make joining a particular church a tacit requirement. And so great care needs to be taken when there are comments based upon religion and when there's any kind of indication that that is a job classification. For those of us who are over 40, we fall within that protected classification. And you do see ageist comments. You know, we need to get rid of dead wood. You know, we need to get the old guys out. We need fresh ideas and fresh thinking. Some of those can, although couched, can be seen under the right circumstances as ageist comments and inappropriate. And age can also be a subject of harassment as well as discrimination. Now, a lot of times we think of race and national origin interchangeably. It's really not. National origin will be discrimination based upon your place of where your historically individuals in your family have come from. For example, I'm dealing not for the city of Socorro, but another client, an Italian American, asserts that she was discriminated against because she was Italian American. I've had cases, again, not for the city of Socorro, but other cases in which, for example, a Puerto Rican employee can assert that they were being discriminated against by Mexican American employees of an employer. And so it can take on different connotations. And so national origin does go well beyond just the race of the individual. Also, under the Americans with Disabilities Act, you can have, obviously, a direct claim for discrimination or failure to accommodate an individual with a disability. And generally speaking, under the Americans with Disabilities Act, you have to be A, an individual with a disability, first of all, and B, you have to be qualified to perform the essential job functions either with or without accommodation. And so that is the classic definition. You have to be both qualified and be disabled. And so it's a fairly narrow box. But I have seen cases where people have asserted that they were harassed because of an assertion that they were disabled or were viewed as disabled. And so that's another classification that you have to be cognizant on when there are statements made with regard to someone's disability, inability to perform certain tasks, etc. Well, what is harassment exactly? And it can be a complex issue, but it is generally considered to be an unwelcome verbal or physical conduct based upon a protected classification. And it can be race, color, religion, sex, gender, just what we've gone over. Importantly, it has to be severe or pervasive conduct that interferes with an employee's work performance. And talk a little bit more as we go through this, but what is severe or pervasive? Think of those two terms as separate, okay? There's severe, which means it can be, under some circumstances, rarely a one-time deal, but it would have to be almost a physical assault. Pervasive, when you're talking about pervasive, it's when you have harassing conduct, inappropriate words, but it's pervasive. It's an entire department, it's constant, unending, nothing is done about it, okay? And so, it's not, I'm going to get into this a little bit detailed, but there's some fairly strict requirements with regard to what is or isn't. And it's more dangerous when managers are involved in the situation. And so those with supervisory, those in a position of authority need to be particularly cognizant of the need to really set an example, make sure not only that others in whichever department you're in are not engaging in inappropriate activity, but also that you yourself are setting the proper example. Oops, excuse me. So where is the line? People often assume, they hear the words harassment. They assert that, listen, I'm being harassed by my boss at work. Well, that can be a catch-all phrase. When someone is being criticized by their supervisor, when a supervisor is harsh, and we all have experience with a harsh supervisor, well, that's not illegal harassment. Sometimes supervisors are difficult, and as a general rule, you would hope that doesn't happen, and as supervisory personnel, but rude and offensive behavior in and of itself in the workplace is not illegal harassment. The individual has to be targeted because they fall within one of the protected classifications that we talked about. And so keep in mind that it has to be focusing on those characteristics of the employee. Harassment because an employee is female, harassment because an employee is Puerto Rican, harassment because an individual is a Muslim. Those would be when you have unlawful harassment. What we often see is sometimes you have supervisors who are equal opportunity with everyone. They're just difficult to work with. That in and of itself is not unlawful harassment. And again, as much as we like to change that, it's important that everyone understands that being unlawful and illegal, it has to be because of the correct classification. Stray remarks generally in and of themselves are not going to be actionable. And obviously under the policies of the City of Socorro, stray remarks and other statements by employees, inappropriate statements, and we've all seen it where someone gets carried away, says something, you can see that people are offended. If that's not an ongoing thing, the individual doesn't have a history of it, it could potentially be a stray remark. And that should be dealt with on a supervisory level. But as a matter of law, it is not an actionable issue. And so bear that in mind as well. Now this is the City of Socorro's anti-harassment policy. And bear with me because I want to go through this, read this to you because it states the policy in the City of Socorro and it follows fairly closely what the state of the law is. The City of Socorro is committed to a work environment in which all individuals are treated with respect and dignity. Each individual has the right to work in a professional atmosphere that promotes equal employment opportunities and prohibits discriminatory practices, including harassment. The City of Socorro has a zero-tolerance policy for harassment of any type, whether it comes from supervisors, co-workers, customers, clients, tenants, vendors, or third parties doing business with the City of Socorro. Therefore, the City of Socorro expects that all relationships among persons in the workforce will be business-like and free of bias, prejudice, and harassment. Any employee who commits any inappropriate acts may be disciplined or, where appropriate, terminated without notice. And so, the policy of the City of Socorro actually goes, to a certain extent, even beyond what is required by law. That, there will be discipline, or can be discipline, even when there may not be issues that would rise to the level of unlawful behavior. But if it's inappropriate behavior, the City of Socorro can and often will and does take action based upon that. And so, as supervisory personnel, you need to think long and hard when you see that. You need to make sure that it's reported and action is taken. And you can't assume that, well, it may not be unlawful, it may just be a stray remark. You still need to think about it. Take action. Call Ms. Rodarte, report that type of behavior. So each of the individuals in this room has a role in that process. And so specifically, what are some of the things that can equal sexual harassment, things that you need to be on the lookout for? Well, obviously, when we think of sexual harassment, the one thing that comes to mind for all of us is unwelcome sexual advances. And that happens, and it can't be tolerated. When you have individuals, co-workers, who are engaging in that type of activity, making advances towards other employees, when it's unwanted, keyword unwanted, then that's inappropriate. As supervisory personnel, you need to be even more cautious. There just shouldn't be any of that activity from a supervisor to subordinate staff. Request for sexual favors flows from that. That is going to be inappropriate in virtually every context. And so supervisory personnel need to ensure that they are setting the appropriate example. And then you get into some of the more indirect issues, the verbal conduct, and which can increase to physical conduct. But as we were discussing, verbal conduct, it has to meet the standard of severe or pervasive. And so, and it has to be enough that it impacts the individual's employment, that they feel like they can't do their work, and it's impacting them. And so the stray remarks aren't going to be enough, but if it's a constant type of situation that's unredressed, then that is when it rises to the legal level of sexual harassment. And that is what we refer to as hostile work environment. When you have statements being made, activities that are inappropriate. Quid pro quo is the other type of sexual harassment, and that is typically, and that's generally going to be on the supervisory level. And quid pro quo, it's Latin, it means this for that. And that's when a supervisor, generally speaking, will say, you know, I think you are in line for promotion, but I think you should go out first. You know, I think that would solidify your promotion. When there is any tie between pay, promotion, demotion, termination, and any type of sexual relationship or act. And so quid pro quo is obviously going to be more dangerous, and if that happens, it's pretty clear cut on its face. Hostile work environment is less clear cut, but still inappropriate. This is the legal requirement. We've talked about the first two items, the unwelcome harassment based upon an individual's sex. And when we're talking about this, you can insert age, you can insert race, depending on what the classification is. We've talked about the harassment affecting the terms, conditions, or privileges of employment. It has to be such that it does impact the individual's performance of their work. The third element is significant, and I want to talk just a little bit about that, because the employer must be shown to have known or should have known about the harassment and failed to take appropriate activity. What that deals with is those situations where the employer never knows that something is going on. Someone is suffering in silence, not reporting things. Well, the employee has a responsibility under the policies of the City of Socorro to report acts of harassment or discrimination. And then the city has the ability to investigate and take appropriate action. And there can only be legal liability. And what I mean by legal liability, if there was a lawsuit, the employee could not have recovered if the city wasn't put on notice and the city failed to promptly act, to take remedial action. So in those situations where harassment is reported, it's investigated, someone is reprimanded, generally speaking, there's not going to be liability. That's why as supervisors, it's absolutely critical that you take action. Yes, Chief Mullen.
Bruce, I was going to ask, like the police agencies typically respect the chain of command. This does not relate specifically to the chain of command. If an employee is suffering from this type of environment, they don't necessarily have to report it through the chain. They could go to HR or possibly another supervisor if they feel comfortable.
That's correct. There is, through the policy of the City of Socorro, as stated in the handbook, you have the ability to go, to not follow the chain of command, to go directly, for example, if an officer who is supervised by one of the sergeants has an issue with the sergeant, could bypass the sergeant, go directly to you, or bypass you and go directly to Ms. Rivera. And that's true for every department in the City of Socorro, is that they can, employees are not only have the right, but they are encouraged to go outside the chain of command as necessary. Okay. And so it's critical that the supervisors let HR know so that if there is an investigation, there can be prompt remedial action that is taken. I just wanted to mention briefly that we still, not at the City of Socorro, but in other cases, I do see on occasion inappropriate posters, people sending inappropriate emails, inappropriate jokes, inappropriate links to different websites. All of that can be considered inappropriate. And that's why none of that should be allowed to take place. And there's a view that, well, maintenance workers are just going to, yuck it up a little bit more. We have to apply the same standard to everyone. And there's a view that, well, this department department's a little different, this department's mainly guys, you know, we can, no, that's not good enough. We need to have one standard that applies across the board, and when there are issues, they need to be raised. This is important. There's the belief sometimes that only employees, fellow employees, can commit sexual harassment. There can be situations in which non-employees can commit sexual harassment, can be sexually harassing an employee, or committing any other acts of harassment based on race, age, any of the protected classifications, if the employee informs the supervisor and nothing is done about it. And that's going to be the key point. When you have the employer, again, has to be put on notice, hey, I keep going to deliveries to this place of business, and every time I'm there, they make crude comments, or the owner keeps asking me out, I feel really uncomfortable with that. Well, you can't just assume at that point, well, it's not a city employee who's doing it, so we can just blow it off. No, we have to take steps. And if it means that the city has to take action with regard to terminating an agreement or contract, then the city will look into that. And so there can be situations where non-employees can create a claim for the city. Also, there's the belief that, you know, there can't be harassment male to male or female to female. And that can happen if it is truly based upon sex. Now, if it's just ribbing and whatever, may not be appropriate, but that's not going to be because of sex, but there can be situations just cheating.
Bruce, can I ask another question in regard to that? Employee going to another vendor, for example, and being subjected to that kind of environment. What if the supervisor transfers that employee to another area? Could that be, I mean...
Yeah, no, I mean, that's prompt and remedial. It does remove the individual out.
But could it be seen as punitive action against the employee?
Depending on if the employee is not good with that.
Yeah, that's what I mean.
Yeah, if you do transfer, change the responsibilities, potentially, and the employee is not satisfied with that, then that could be an issue. I think that those are the types of things you really have to take a look at. Mr. Rodarte doesn't need to get involved and really decide what is our strategy. And who are those that are going to be protected? It can be another issue. First of all, obviously, the individual who is the target will be protected. But there can be situations where the target is fine, you know, that a female employee is joking and engaging in back and forth of a sexual nature. Well, another female employee who's not involved directly but overhears this is just troubled by it. Doesn't feel like she should have to listen to these people that continue to go back and forth over inappropriate, what she believes to be inappropriate comments. Well, action would need to be taken. She's not the target. They're not aggressive, but they're saying where she can overhear inappropriate comments. And so the bystander in that scenario can have a claim if she reports it and no action is taken. And there, similarly, witnesses. There can be situations in which witnesses would overhear and be involved, and you can't take action because they are, in fact, witnesses. So why is this important? Why are we here? Why do we think that department heads as well as the city council should receive training on this particular issue? Well, it's a basic issue. The city of Socorro does believe that all the employees should be treated with dignity and respect and in accordance with the law. Secondly, engaging in or condoning or not reporting is in direct violation of the district or the city's policy. So you have to keep that in mind. And finally, we have to comply with the law. We're here to make, in every aspect of what the city of Socorro does, to ensure that everyone complies with the law. I want to talk a little bit about retaliation. Retaliation is when someone has reported what could be discrimination or other acts. It could be something that they were the target of, or it could be something that they saw someone else be the target of. It could be having filed a prior charge of discrimination or prior lawsuit. Well, retaliation is when there's adverse employment action, which would involve significant events, demotions, terminations, salary reductions. It can involve, I'm aware of a case from Houston in which you have an individual, same rate of pay, but transferred to what was a less prestigious position. And so meeting that higher standard can be difficult, but if an individual is retaliated against, they would have to show that in fact there was an adverse employment action. And employees who have asserted their rights are entitled to protection, and any of the supervisors, other personnel should not take that type of action. It's just important to treat all the employees that you have similarly for similar events. And so it's just important to ensure that when you have an employee who may have had a reporting history, that you would treat them just as you would any other employee within your department. No better, no worse. You need to make sure that you're applying standards appropriately to the extent that they're consistent, or that they're issues that are similar. You need to treat them in a consistent manner. And so it's critical. What do you do to avoid retaliation? Make sure that you're documenting. And this doesn't just go for adverse employment actions that for individuals who have asserted rights, but really across the board, you need to make sure that you document the reasons for any adverse employment action that is taken. Ensure that it's consistent and appropriate, and also it's critical. You need to have Ms. Rodarte's involvement when you're dealing with these types of situations. She can provide counsel under certain circumstances. She'll get me involved if needed, and it's important to have her involvement to ensure that what's happening is consistent, follows city policies, and is appropriate to the given situation that you have. Let me talk a little bit about the reporting policy of the city of Socorro, because it's important that every supervisor understand what happens, how are this reported, and what takes place. Again, let me just read real quickly the policy with regard to reporting. Any employee who feels that he or she has been discriminated against or harassed, listing all of the categories, is required to immediately report the matter to his or her supervisor. If an employee has reported harassing, bullying conduct to his or her supervisor and no action was taken, or if the employee believes it would be inappropriate to discuss the matter with his or her immediate supervisor, he or she may bypass the supervisor and report the matter directly to the Human Resources Director or the City Manager. And so you see, this is what we were talking about before. What happens when you have a subordinate or yourself, rather than reporting directly through the chain of command? What is the process? Well, you can bypass your supervisor. You can go to Ms. Rodarte. You can go to the City Manager to make the report. And what is important, and it's bold in city policy, and in all caps, and that's immediately. And that's the responsibility of the employee. And it's difficult to investigate a complaint of harassment that's 6 months old. Memories fade, no one remembers. No, I don't remember. When was that? And so that's the employee's responsibility to immediately report it so that something appropriate can take place. And you'll have these conversations with your subordinates, and it's important that you communicate to them the importance of this. And I know Ms. Rodarte will have additional education and training with regard to other employees, but you as supervisory personnel, and to the extent that we would ever get to the elected official level, need to counsel people. If you have an issue, report it. That's what's required. If you don't feel comfortable reporting it to your supervisor, you don't have to. You can disregard the chain of command and go directly to Mr. Morphley or Ms. Rodarte. Continuing on with the City of Socorro's policies, all employees, supervisors, managers, directors, and officers have the responsibility to comply with this strict policy and are required to report any observations of harassment or discrimination. That means that supervisory personnel, if you see something, you need to deal with it. You can't assume that, listen, it's up to the employee. If you perceive that, then you need to take action yourself. If the city of Socorro determines that an employee has violated this policy, appropriate disciplinary action up to and including discharge will be taken. And so, when there's an investigation, action will normally be taken depending on what the findings are. And so, it's important that everyone understand how significant that is. And the policy specifically states that there will be no retaliation against any employee who in good faith reports discrimination or harassment in accordance with this policy. A couple of the key words there are in good faith. And so, if someone is using the process maliciously, that is not effective. If an employee is utilizing that to make sure that they change supervisors and it's found not to be factual, well, under that circumstances, there may be disciplinary action with regard to the employee. Unless that's the case, there can be no action taken with regard to the employee. So what are your responsibilities as supervisory personnel? Well, each of you should periodically review the employee handbook in the city of Socorro. You are required to know what's in it, know what the policy states, and comply with that policy. And as we discussed, you need to make sure that you report any complaint that you receive from your employees. And so when you have, whether you observe it or not, receive a complaint from any of the individuals that you supervise, you need to immediately report that to Ms. Rodarte. Okay? And it'll be necessary at that point for Ms. Rodarte to look at it and determine what action is necessary. Is it an employee just simply complaining about an evaluation that doesn't bring into it any of the laws that we just talked about? Or is it something that needs further investigation? And that's where HR and Ms. Rodarte's expertise comes into play. She'll examine that, determine, listen, what do we have here? Is this an issue that needs further investigation? And what should be done at that point? And it's important when you are approached with these situations, and the supervisory personnel will be approached with an employee with some form of complaint. You need to, as supervisory personnel, demonstrate your willingness to hear and to discuss the complaint. You need to be willing to sit down with that employee and get that information. And you may be thinking to yourself, well, this is nothing. Well, that's not important at that stage, okay? What's important is that you sit down and get the basic information. It's important that you be open with the employee so they don't feel like, I can't report this to my supervisor. Again, you must immediately report what you received to Ms. Rodarte. And one thing that takes place sometimes is employees will come and say, listen, you got to keep this confidential. Well, don't promise confidentiality. There can't be an investigation with 100% confidentiality. It's not possible. And so when someone does come in and tells you, but you got to keep all of this between us, it's completely confidential. No, don't make that promise. Because you're going to immediately have to get Ms. Rodarte involved. And if there is, there are situations sometimes when the employee makes a complaint and says, listen, I just don't want anything to happen, but I just want to let you know. I'm sorry, you can't let it stop there. You have to go beyond whether or not the employee wants you to or not. You have to make the report and make sure that it is handled appropriately. And the fact that the employee doesn't want to proceed may be a fact that Ms. Rodarte thinks is significant in her investigation, but nonetheless, you need to make sure that that does go through the regular processes. Never object if the employee says, listen, there's an issue, I just need to go talk to Ms. Rodarte about it. That's appropriate. Never discourage someone from going beyond your level to report to someone else. Make sure that you respond to the employee's complaint as soon as possible. And again, you cannot retaliate. If you think, wow, this individual is not being truthful and accurate to me at this point, well, there hasn't been an investigation. that's premature. You can't let that thinking into your head. You need to make sure that it's handled appropriately, and then any action that's taken after the fact will be determined by the supervisory personnel. Investigation, multiple ways that they take place. Ms. Rodarte will generally handle those. The city attorneys can be involved, and sometimes outside investigators are involved. And as supervisors, as department heads, you need to understand that you will need to be interviewed, and you're going to have to provide information. And you may not like it, but that's part of the process. And as supervisory personnel, you can't put up a brick wall and say, I'm not going to talk to you, I'm not going to cooperate, I'm going to be difficult. If you do that, that's going to be an indication that you are not fulfilling your job requirements and responsibilities. And so that is part of your duties to cooperate. It's part of your duties to make sure that witnesses will be made available. And so take that very seriously. After the investigation has taken place, appropriate action will take place. And it's important that steps be taken to ensure that additional instances don't take place. And so they can take a whole variety of issues. Sometimes an employee just needs to be spoken to and reprimanded verbally. Sometimes in writing. Sometimes demoted. It all depends on the facts and circumstances. I can tell you this. Under the laws, the law differentiates between a typical employee and a supervisor. They hold, legally speaking, you are held to a higher standard. And so do expect that if there's a violation by supervisory personnel, it will be taken more seriously. And it's important that it be done that way. And when there is an investigation, it's important, like I said, to have Ms. Rodarte involved so that there isn't a department investigating itself, that a supervisor isn't having an investigation by subordinates of his activity. I want to talk just generally about disciplinary issues because we need to put all of this within the context of how do we deal with discipline, how do you work with your employees, and it's, first of all, extremely important that all discipline be consistent as much as possible. Now, every situation is going to be different, and you have to make different decisions based upon different situations. But when you have an employee who shows up late, and you have another employee engaged in identical behavior, well, you need to treat them in a similar manner. There are situations where the misconduct is totally different. Within the police situation, there's a difference between an illegal shooting and an accidental discharge, for example. And so different situations will require different discipline. Importantly, it should be appropriate to the misconduct involved. And when you look at the discipline, when you look at the action that you're taking, is it appropriate based upon what is taking place? And, you know, if you're relying upon prior events to support that, make sure that you've documented those prior events previously. When it's not involving a termination, make sure that you give the employee the opportunity to respond to criticism. And I've been doing this for about 25 years. What judges, juries, everyone likes to see is that employees are counseled, they're given an opportunity to correct themselves, and they can see what's heading down the pipe. And it's important. We're supposed to evaluate our employees. We're supposed to give regular feedback to the employees of the City of Socorro. And it's important that you tie what has happened in the past to the current event. And so if you have a situation where you have an employee who has done prior bad acts before, has prior instances of misconduct, you need to bring them into the current situation to raise them again and say, you know, Jane, we've dealt with this before. In your prior evaluation, we addressed, for example, attendance issues or language issues or whatever the issue may be, and you continue to violate city policy. And so it's important to bring in the prior It's also very important for each of you to understand, it's important to put the responsibility where the responsibility lies when you're dealing with employees, and that is with the employee. If the employee needs to correct the employee's behavior, put the burden on them, because that's where it belongs. If they're not showing up on time, you know, Jane, you need to show up on time. If it's Joe continues to use state inappropriate jokes in an offensive way, you know, Joe, we've dealt with this before, and you either correct it or there's going to be a stronger disciplinary action taken. And so, whatever the situation is, make sure the responsibility is where it belongs. And documentation in what we do is critical. So make sure that you are keeping the important documents of the employees, the evaluations, the write-ups. If you're having multiple verbal counselings, you know, document that you are giving an individual a verbal counseling. You don't have to necessarily give the employee a copy of your notes that you did verbally counsel that employee, and keep that in the file. Make sure, one thing that's very important is that you make sure that all of the records go in the personnel file. What happens a lot of times is the supervisor will keep a separate file on an employee. It doesn't end up with Ms. Rodarte. The supervisor leaves, the files disappear, and counseling that's happened for years, there's no record of it anymore. So make sure, part of your responsibilities as supervisory personnel, to pass on that information to Ms. Rodarte. And it helps not only you make informed decisions, but subsequent supervisors make informed decisions. And plus, a lot of this is just required by law. I want to talk a little bit about problem areas for managers and things to be cautious of. Email communications. People email and text very quickly. They don't think oftentimes a lot when they do send this. Remember that any communication about an employee can be relevant at a later date. So if you're going to put something in writing, whether email, text, memo, whatever, give some thought to it. Make sure that you're saying things appropriately, correctly, that you're following the city policy. Make sure that you are not making inappropriate comments yourself. Keep business to business. Make sure that when you're talking about the requirements for employment, you focus on that issue and that issue alone. There's no reason for people to make snide, inappropriate remarks about subordinate employees. Keep it focused on their work and their performance. And individuals often, one or two catty, inappropriate comments can have a major negative impact. They just don't have any role in written communications. Social media can be dangerous for individuals. As supervisory personnel, you need to make sure that you're not commenting about work, your subordinates, issues like that on social media where your subordinates can see it, you can raise issues, and it can result in legal claims. So make sure that if you're on Facebook, whatever, if you're on any social media, you don't state things about city personnel activities, subordinates, and you see it fairly frequently, where someone will criticize a subordinate. You see people criticize superiors as well, but for managers, all of that will come out at some point. And so be cautious about that. An issue that is also difficult is where's the line when socializing with staff? I would counsel you to be extremely cautious about any after-work activities. It's maybe one thing to go have lunch with 3 or 4 of your subordinates. It's another thing, in my mind, to socialize, go drinking, and that type of activity. I've seen too many claims for other clients, not for the city of Socorro, where that takes place. So managers need to give some thought about that. And also, you know, one of the things that I see, and it's a problem area, is when you have the rapidly changing evaluation of the employee. When it's totally inconsistent. Great employee, horrible employee. So make sure that you're really consistently appraising that employee. If they're having difficulties, make sure that that is documented. It's really easy to be nice someone's friend. That's part of the problem with socializing with subordinates. It makes it more difficult to give them honest feedback. And so be cautious on that.
Bruce, if I could ask you,
Yes.
just to elaborate on evaluations. We have annual evaluations. My recommendation is they should bring that evaluation out on a consistent basis, bring the employee in to discuss activities
Right.
on the evaluation. So my point of that is the annual evaluation should not be a surprise to that employee.
Right.
There should be discussion along that.
You should, and in fact, our policies expect that as well. So, yeah, that is definitely the appropriate way to go on that. And it's important that supervisory personnel know that HR is their friend. It's a source of a lot of information. It's important for you as managers to have HR involved. There's many times when claims can be quickly avoided through proper HR practices. And so when you do have issues, do get HR involved. And I'll tell you this, it's important just for your careers. Because if you say, listen, I went to Ms. Rodarte and she said that was fine. Well, that gives you protection as well. And so, in my practice, a little bit of time can avoid a lot of pain later. So make sure that you understand that. And so it's been a real pleasure discussing this with you today. I can't take.
Just one question. So what are the consequences for false accusations? Say, for example, just to, get someone in trouble and it's telling the truth, what are the consequences?
Well, if there is a situation where someone makes a false report, Ms. Rodarte would examine that situation, and there would be potentially some disciplinary action to the employee who has made a false claim or false report. Again, it would depend on the specific situation, and so there isn't one single answer to that, but it's taken seriously, but caution needs to be taken.
I have a quick question regarding unwelcome. Just like right now, our culture, where we live in, we're very touchy-feely. Right now, at an official meeting, Judge Garcia and we had. Is that unwelcome?
No, that wouldn't be unwelcome. I mean, culturally, I grew up in El Paso. I'm used to hugging, as well, particularly.
So as long as we are, is it okay for me to?
If someone said, listen, I'm not comfortable with it, then obviously you stop. But that would not be sexual harassment. Even if you did it and someone tells you that's not appropriate, it would only potentially rise to that level if you continue to do it.
After you're told not?
After you're told not to. And so you have to look at the cultural expectations. You have to look at, listen, if two employees are off joking and telling tawdry jokes on breaks or over lunch, there's not a lot we can do about that. We may not like it, and it may technically be in violation of policy, but it's certainly not unwelcome by those two. They're always out there talking about it. And you may, if it's on their own time, there's not much you can do about that. If other people overhear it and it's impacting the group, yeah, sure, you need to put an absolute stop. Say, you all can talk about what you want to talk on your breaks, as long as people can't hear it. If you're out for lunch, again, as long as it's not making people uncomfortable, that's one thing, but in business hours, not going to happen.
And the only reason I ask them is in my department, sometimes we go and go through different situations where people are going through a rough time. And they do cry on your shoulder, and then is it okay to comfort them and say, it's okay?
Sure, that's
They're just
absolutely
being
appropriate.
compassionate.
Yes, I think that type of activity is was a pleasure. I know we've got the city council meeting started. Thank you all very much.
Thank you.